in, but we'll kind of get started now. I want to be mindful of our time and the fact that we have potentially a lot of folks that may want to contribute to the discussion today. We want to be able to get as much conversation as we can about some of the policy issues we're going to talk about today. I want to start this morning by introducing Stephanie Woodard. She is the Solicitor General of Hall County and the Chairwoman of the Commission. I'm getting feedback, so I will ask again for folks to please yourself or just help me with getting people muted so there's no feedback. Okay, that's a little better. I will now turn this over to Stephanie Woodard, the Chairwoman of the Commission on Family Violence and the Solicitor General of Hall County, for the welcome and purpose.
Good morning, everybody. It's so wonderful to see such a large group. Some of the, I guess, good lessons of COVID are good things that have happened to be able to be together, this many of us on such a rainy and cold day up here, and have this very intentional talk from the comfort of your own space. This is pretty phenomenal. We may, depending on how these continue to work going forward, may never have to go back to driving to the Capitol and finding a room to be able to spend time together to share this, our thoughts about the upcoming year and the upcoming session. So every year we have our annual roundtable where we invite all of our collaborators in the work, all of our allies, all of our people that do service providers and are looking at legislative issues and upcoming funding issues, everything that could potentially touch our work in every field together to talk about our intentions for the next year. Primarily in the legislature, knowing what is coming up and dissecting and really looking at some unintended consequences of things, or attempting to. So we're very excited to see this large attendance. We're excited about having a conversation together. You know, I like to begin our meetings with some specific intention. And today I'm going to read a quote from my favorite Mr. Rogers, because I think it can inform our conversation as we go forward. It is very dramatic when people come together to work something out. It's easy to attempt to annihilate your opposition, but what is really exciting and really powerful is to see people with differing views come together, respect one another, and get the work done. So that is our purpose here today. I'm going to hand the baton back to April as she goes through what we know now and what we're looking at going forward, and then can't wait to hear from each of you on how we can work together in the upcoming year.
Thank you so much, Stephanie. Really appreciate that, and inspiration for today. Very fitting indeed. All right, folks, I'll jump right in and go into some of the legislation that we've been successful at getting passed over the last couple of sessions. Some of us are very familiar with this, with some of these bills that have now become law, because we work closely in and around the Capitol in the session, but not all of us are. So I'm going to just quickly run through this. Many of us are familiar that in 2021, Georgia enacted the Dating Relationships TPO bill. In the Georgia Code, it's section 1913A-1. Interesting to note that it is not a part of the Family Violence Act, but this did establish protective orders for people in dating relationships. There is a multi-factor test that judges can use to determine the nature of the relationship, because as you know, with the Family Violence Act, there are certain qualifying relationships that you have to satisfy first before you can move into the requirements for getting a TPO. And so the same thing applies here. You have to satisfy the relationship before you can then move into the conduct to see if you qualify to get the TPO. So it's a multi-factor test. If you work as an advocate or any around or with any domestic violence victims, you might want to familiarize yourself with this particular statute. It is now 2 years in, so many of us probably have already had some experience with it. But notably in 2022, we did slightly amend this bill. When it was initially enacted, there was only a 6-month provision so that judges could only look at incidents and conducts that occurred in the relationship in the prior 6 months. This past legislative session earlier this year, that was amended to allow for 12 months. So the judge can look back 12 months into the dating relationship. Please again, I'll just continue to make that announcement to stay on mute to avoid distractions. But again, earlier this year, we were extended so that now you can look back 12 months. I believe the Superior Court forms that were now approved by the Georgia Supreme Court and are now the standard forms for this particular TPO. I think they've already been amended to reflect the 12-month amendment. But otherwise, this was a pretty significant piece of legislation that we got done in the last couple of years. If you might not know, there was also another bill that passed into law. And this was HB 236, the bill number was, but this is about safety checks. This bill allows for a protective order recipient or the petitioner of a protective order. Once that protective order is in place, that person can then go to their local law enforcement and affirmatively request, so they have to request it, that an officer either show their presence or do a ride-by safety check in or around their residence. I believe it may also apply. They can ask for it around their employer or place of employment. Notably, this is discretionary. So the officers are not required to give a constant presence or do this at the whim of the victim or the person with the protective order. But they have the discretion to decide the frequency, the intervals, and the times for the presence of the law enforcement or the ride-by. And therefore, they also included that this does not create a cause of action for failure to check. So in the event that there's an incident or someone violates the protective order and the police happen to not be there during that time, you can't then sue them or create liability for anything that happens because they were not there at that time. So that's HB 236, which is also now law. Those were just a couple of the bills that were significant in the last year. We'll kind of, if you have any questions or remarks about that, we'll kind of hold those to the end. You can put questions in the chat. I may or may not see them right away, but Jamila, you can certainly let me know if there's a specific question that I should jump into right away while I'm remarking on some of the items. But moving on, I want to talk about some of the domestic violence and sexual assault policy issues that are under consideration for the commission for the 2023 legislative session. As you know, the Commission on Family Violence, part of our mandate as an agency is to advise and participate in guidance for legislators around policy issues that impact people who are affected by domestic violence. And so we are always either assisting and supporting people with legislation that has that impact, or proposing such legislation that would make a difference in the lives of people who are affected by domestic violence. So the first item I'll just briefly mention is it was in the 22 legislative session, it was HB 54. And this was not a bill that GCFV specifically brought forward. There was a representative, a House representative who drafted and created this bill, but essentially it would require a stay in custody proceedings, so child custody proceedings, when there's one of the parents that has been criminally charged in the death of the other parent. So if there's pending criminal charges and the trial has not yet concluded and there's not yet been an outcome, this bill would then say to a judge in a child custody proceeding on the civil side that they must stay that proceeding or pause essentially that proceeding until the criminal case is concluded. That bill made it out committee last year, but did not get a vote on the floor. So we have reason to anticipate that this bill may be reintroduced in the upcoming session. We're going to stay in touch with that representative and offer support as needed to this bill. The next policy issue that we are aware of, and I'll say for the record, I don't know if she's on, I did not see her, but Joan Pretty from Project Safe brought this issue forward. And it's a bit dense, so I'll do my best to articulate it if she's not present to share it for herself. I think she told me she wouldn't be able to make it, so I would introduce it. But this is basically trying to address confidentiality in the actual residential address or location of DV safe houses and sexual assault centers as well in Georgia. So we know that safe houses are supposed to be private, undisclosed locations to maximize the safety of the people who go to those places for shelter when they are leaving domestic violence situations. One of the things that Joan realized, typically your address, because of the title to your property, is public record, and taxes, tax related issues, all of that stuff, property taxes. It's usually public record. So if an offender or an abuser had the wherewithal and the determination to dig into public records through the property tax records or through going to look at the title or the deed. I think a title is more cars, but deed for the house or the property, they would presumably find that information and be able to get that address, which should be highly guarded and confidential for the protection of the people in the safe houses. Joan went through a local process in terms of petitioning her court and going through several steps to address the issue for her particular safe house with Project Safe. And she has now gotten her address confidential. But what we realized is this may not be the case for safe houses across the state, as well as if a DV shelter or organization purchases a new property and gets a new deed, that deed would then be recorded. The property tax records would then be public.
April, I don't mean to interrupt you, but Donna Bracewell is here and she has some stuff to speak on Joan's behalf.
Okay. Donna, yes, I'll let you jump in if you'd like to kind of articulate what Joan is proposing in this regard for the address confidentiality.
Thank you. You were absolutely right with everything you said. The only thing she wanted me to kind of bring up and make sure we thought about was if we were to go forth with any sort of legislative process for this across the board would be the implementation of it, and being concerned that, there are some workarounds right now, but those are local. But the implementation of it with new statutory language would need to be specific, required for a process of implementation. That was mainly where she had concerns, because it leaves us really where we are now, which is each shelter going locally to their judge, using an attorney, and figuring out what works. She looked at the Texas model, and they do have a actual model for this. And it doesn't just cover family violence shelters. It's used for a lot of different agencies. It's used for individuals, judges, probation officers, anyone who wants their address to be confidential due to working in the systems. So she did want me to bring up that it's under their tax code. And I can either send that to you guys or we can talk about it further. I don't know a lot about the Texas code. She was going to look more into that, and I think someone else was as well. But any of that sort of legislation, making sure that if we talk more about it, that implementation would need to be a really important part of that.
Absolutely. And yes, that was part of the conversation we've had. So thank you for adding that. Because, implementation is something that's easy to forget when you're working so hard to get a bill passed, and then you realize it's passed. Now, how does it work? And that's something we definitely learned a little bit with the dating violence bill. So that was a nice lesson learned. But yeah, she's talked about working on the implementation, and the Texas code process is actually a pretty good one. We've also decided what might be easier or might be wise in pursuing this particular issue is to consult potentially with a property attorney or real estate attorney or an attorney that deals in property taxes, property deeds and things like that, who may be able to be more familiar with some of the statutes that would be impacted by this bill, and may also have some advice for process as well. So yes, that's a critical piece of what would need to occur for this. We intend to try to move this forward in 2023, but Joan and I have both agreed that it's more important to get it right and introduce it appropriately, again, with a process for implementation than to rush and introduce it. So this is a potential issue that we're keeping our eyes on, and GCFB is likely to support and endorse as well. Okay, I'll move on to, this is kind of a reboot from something we have all been familiar with and have tried before. It has been supported. Actually, I have a slide I'll walk through on this one. It has had bipartisan support in the past, but has somehow failed to cross the finish line in the end. As we know, firearm-related family violence incidents account for a disproportionate amount of domestic violence-related deaths across the state. This bill would clarify Georgia's law, which is at the moment vague to the point of almost non-existence. But it would clarify Georgia law to reflect that any persons who are convicted of family violence offenses or subject to a qualifying protective order. Note here that the dating violence protective order is outside the family violence statute, like I said earlier, and therefore this particular protective order might not qualify unless we are able to affirmatively write it in as one of the qualifying protective orders. But a qualifying protective order, that person subject to that or an offense would not be able to receive, be in possession of, transport, purchase, or transfer firearms. We all know that firearms is frequently a hot button issue in Georgia and certainly across the nation. We believe that it's important to protect the rights of responsible gun owners, and that is a point that is also agreed with bipartisan support. But we know that when it comes to family violence offenders and abusers, if they decide to move to escalate their harm against that intimate partner, a firearm is frequently the means that they use to inflict fatal harm. So we certainly want to address that. I think policy is the way to go in this issue, as well as local community responses. I think a lot of communities are also actively thinking about and working on, and in some cases have processes in place to try to address it locally. But certainly a clarifying and a consistent law in Georgia that would give guidance to folks would be most beneficial for this issue. Also, so the bill we're looking at is intended to enhance accountability and for people who are not in compliance with the law, or in other words, people who choose to be in possession of firearms despite the prohibition. If you should be aware that currently under federal law, the Lautenberg Amendment does prohibit people convicted who have been convicted of family violence offenses, including misdemeanors, or people subject to qualifying protective orders from being in possession of firearms. But local or state public safety officers cannot enforce federal law. That's why we need that Georgia law. We also know that this year there was a significant federal legislation that sought to include dating relationships. They consistently called it closing the boyfriend loophole throughout the year. So that may be the buzzword that you're familiar with. But essentially, we think that Georgia needs to act on this issue and figure out what is the best approach for this state. We at the moment have been developing a legislative packet for this. We've had some conversations with state legislators and have received indication that there is, again, bipartisan support for this. So this bill is likely to be something that we attempt to move forward on again in 2023.
And
Next,
and L. Knott is here, April, and we do have one question, but L. Knott is here from the YWCA.
sure. Elle, would you like to jump in and share a little bit? I know we've been working closely with the YWCA to develop and prepare on this issue. So certainly want to allow our partner there to make some comment. Elle?
Hi, everyone. Good to be here. I'm here in Ashley Oliver's stead. So what she asked me to do today was to confirm that we'd be supporting any legislation that the coalition brings forward, and then also share our policy agenda. So if this is not the right time for that, I can do it when you move on to that time.
Yeah, if you want to talk a little bit about or if you have anything to add around the firearms access, that'd be great. And then I'll give you a chance to share your additional policies or legislative priorities in just a moment, if that's okay.
Okay. I think that Ashley is probably a better person to talk to about the firearms access. I'm sorry that she's not here, but if anyone has questions for Ashley about that, I'll drop her email in the chat.
Sure, that'd be great. But essentially, I do want to, we are working with the YWCA actively on this bill. We have developed a draft of language. It is very closely aligned with previous language from the legislation that we introduced. I think it was back in 2019 was the last time we introduced it. And we also did try to work in that dating relationship issue, because we certainly know that, the nature of our society today is that a lot of these intimate relationships are dating relationships and don't fit into the normal or the previously accepted relationship statuses that we've listed legislatively. So this is an issue that is very important to us, and we think we need to continue to work this issue with legislators until we actually are successful. I don't have any speculation about the degree of success we're likely to have this year, but it is notable to me that now we are past, some major election. We'll be at the point that we'll be past the election seasons, and hopefully, therefore, we can have more candid discussions with legislators and get their support.
April, are we going to take any questions prior to moving on, or
if there are specific questions about this, I'm happy to entertain those. But if it's more general, then we have a place for that later in the
agenda. About ensuring the surrender of firearms. So this is a question we probably can answer at a later date. Probably
about surrender.
Mm-hmm.
So that goes to the comment that was just kind of talked about in the last proposal that I just mentioned around the addresses. That's part of an implementation plan. And I think that's also frequently been a challenging issue when we brought this forward. So yes, I think there would need to be a proposal that accompanies this bill for local implementation. One of the things that could be a challenge with that is that we know Georgia has 159 counties, multiple judicial districts and circuits, and that folks tend to operate differently because they look different. We've got rural communities, we've got more urban communities, and implementation could look different. But I think there is a huge possibility that we can develop at least some baseline standards for implementation, and along with this, and accompany that those standards in this legislation. So thanks for that question. But yes, absolutely, the surrender issue is a critical piece of this. And I'll put it out there that if anyone's got any specific recommendations or ideas, or is aware of any other states with procedures in place for implementing surrender, be happy for you to share that with the commission. We'll share our information at the end of this presentation today, and you can certainly reach out to us directly after today. The last one I'll mention is sort of a new issue that came up in a roundabout way. The Commission on Family Violence this year was one of 7 sites that was awarded a grant under the Federal Firearms Technical Assistance Program through OVW. Incidentally, there was an award condition that accompanied that application that we at the time thought we were compliant with, but after we were given the award, we were notified that Georgia law is actually not compliant with this award condition. And so Georgia has a statute, it's OCGA 171015, that has provisions for getting a defendant who's charged with a sexual assault offense that involves penetration, or where there's a high likelihood that bodily fluid was exposed or exchanged to the victim. So that this current law provides a provision for requesting and getting that person, that defendant, tested for HIV and notifying that victim so that they can also, take appropriate action. So what the federal condition wants is that the statute should require that when that request is made for that testing, for that HIV testing, that the testing should be done within 48 hours and the victim be notified immediately thereafter. And they also would like a provision for follow-up testing as medically appropriate. That is sort of a vague condition, but as we understand it, it just sort of means if there's, it could be an issue where the testing was inconclusive, or where there's reason to think that the test might not be accurate. I can't think of a whole lot of examples, but under the, recommendation of a medical professional, if appropriate, there would be a provision that says follow-up testing can be done. And so we are proposing to amend this current statute to bring it in compliance with the federal award condition. And the reason that it is, to me, particularly important that we move forward on this, not only is it, to me, more victim-centered and helpful to the victims of these assaults, but every state agency, department, municipality, organization who applies for a federal award where this condition exists, you will have 5% of your award withheld. So essentially, you just lose 5% of the funds that you would have wanted. And presumably, when you applied for, you budgeted to have, you would lose that 5% of the award. And depending on the size of the award, that certainly can be significant. And so we believe that both because this change would be more victim-centered, or would make Georgia's law more victim-centered, and because it would allow organizations who do the work to help victims and may apply for these awards or these grant programs, we believe that they should get every dollar that could come to them under these awards. So that's the HIV testing proposal that we are interested in pursuing this year. And I believe that concludes the policy issues that we are actively either working on or considering as a commission at this time. So again, in the interest of making this a sharing and dialogue-based roundtable session, I certainly want to take this time to open up the floor to a few of our specific partners and give them an opportunity to share their legislative priorities if they would like. So Elle, if you want to jump in here, I'd like to give the YWCA an opportunity to share what your cohorts are working on this year.
Thank you, April. Again, it's really good to be with you all. My name is Elle Knott, and I'm the Advocacy Program Coordinator at YWCA. And our Georgia Women's Policy Institute this year are working on 4 different policy priorities. The first of which is passing comprehensive and affordable paid family and medical leave for all Georgians, not just state employees. Ensuring that Georgians have the right to bodily autonomy and access to the comprehensive reproductive care of their choice by supporting the Reproductive Freedom Act. Ensuring that families have the right to parent their children in safe and healthy environments by removing outdated restrictions related to TANF benefits. And finally, closing a federal loophole that allows for people who are disabled to be paid a sub-minimum wage by working to phase out sub-minimum wage practices. And again, like I previously said, we'll be supporting the work of this commission. However, we decide to land legislatively. So thank you for giving us this opportunity to share.
Thank you so much, Elle. And we certainly are interested in being supportive and learning more about the work of the YWCA, even to the degree that some of the priorities may not be directly domestic violence related. We certainly think that they have the potential to help folks who are in abusive relationships and looking for more independence and autonomy and to have their own get their lives back, essentially. So thank you for introducing those topics. I will just mention briefly before we move to the next one. The commission meets quarterly. I think most people know that. And in December, we typically propose the legislative priorities of that the commission or the agency staff have developed, as well as priorities of our partners, and we give folks an opportunity to share their to the commission members directly. And there's usually then the vote to endorse and support specific priorities. So if you'd be interested in seeing what the commission actually decides, I'd encourage you to go on and sign up for the commission meeting, which actually is next week, Friday, if you're interested. But at this time, I don't know. I know Karima Dillard was probably not able to join today. She's had another meeting, or I believe she did. But if there's a representative here from the Coalition Against Domestic Violence, huh?
She's here.
Oh, Karima, if you're here, Karima, then I'd like to offer the coalition an opportunity to share any legislative priorities that your organization is trying to move forward with this year as well. And Karima, if you're also willing, if you have a little bit of information to share with the group on Stand With Survivors Day as well.
Absolutely. Thank you so much. It's good to be with you all today. The coalition is working on three policy areas this year, or this session coming. The first one is the funding fix to address the large and consistent funding gap for shelter programs across the state. The next one is an address confidentiality program. Last year, we worked with Chairman Gaines on a bill that was drafted that would include address confidentiality protections for survivors of domestic violence, sexual assault, trafficking, and dating violence. And it includes deed protections as well. So I'm closely following the address confidentiality for DV safe houses legislation as well. We're also looking at Safe Time. Last year, Representative Michael Smith introduced a Safe Time bill that would allow victims of domestic violence and sexual assault to take time off from work without penalty. And we're working this year with 9 to 5 to look at the Family Care Act to see it has a sunset next year, and we want to either extend or remove the sunset and then see if we can include safe time provisions in that bill as well. And then lastly, we're looking at aligning our state code with the new VAWA reauthorization legislation that includes Cadence law, which looks at requiring judicial personnel to receive specific training around the intersections of custody, domestic violence, and child abuse. So we're in the very early stages of looking at how that can be codified in our state. And as far as Stand with Survivors Day is concerned, we'll be in person next year, and we're very excited about that. We're looking at a February date. We haven't confirmed fully yet. We're wanting to see what that legislative calendar is going to look like. But it's likely to be end of January, or I'm sorry, beginning of February to mid-February. So we'll definitely keep you posted. We're in the midst now of deciding on our collective policy agenda, so we'll definitely be keeping you posted. Thank you.
Thank you so much, Karima. We're looking forward to getting back in person for that legislative day with all of us out there at the Capitol, stomping the ground and pushing these important issues. So thank you so much. We look forward to finding out more details about that. At this time, I want to also extend an opportunity to some of our other partners that may be on the call. Again, I'm on a presentation screen, so I cannot see, but I'll just throw out a couple. If CJCC, PAC, or GBI, or any of our state agencies or partners are on the meeting and would like to share or comment, happy to turn the floor over there as well. If there's anyone at this time that we work with on the state agency or department level that would like to share. I can't see if there's any hands raised or anyone's coming off mute.
Don't see anybody raising hands.
Oh, Jay Neal wrote nothing to share as of right now from CJCC.
Okay, thank you so much for letting us know. Thank you so much. All right. If there's no one else, I will move. Okay, Charlotte, thank you so much. I see you in the chat.
Is there
glad to have you here. Glad to have you here, Charlotte. Looking forward to working with PAC and having further communication as well throughout the session. At this time, what I'll do, go on, Jamila, was there anyone else?
No, go ahead. You go ahead.
Okay. So at this time, then I think we offered folks an opportunity to sign up in the form. If you had some other proposals or considerations, I'll now turn it over for Jamila to let us know who has signed up and offer them an opportunity to speak.
Okay, we can start with Natalie Zellner from the Fulton County District Attorney's Office.
Hi, everyone. This is Natalie Zellner from the Fulton County DA. I'm the Deputy DA over Programs, Grants, and Intergovernmental Affairs. And I wanted to talk a little bit about SB 359 and the clauses that were in there dealing with domestic violence from last year. This is the bill that was sponsored by Senator Albers. And it was a huge bill that encompassed a large range of issues from accountability courts to evidence. But within that, there was a particular section that talked about being able to use the prior domestic violence acts of a defendant as actual evidence of the nature and, the character of the defendant. In our office, the number of domestic violence cases is overwhelming, and it continues to grow. Whatever has been unleashed with COVID has not been reined back in. So, having this clause to help make the cases, we think would facilitate significantly, our ability to really effectively make the arguments. And we are seeing, for lack of a better word, repeat offenders coming through. So, and maybe they haven't committed the homicide yet, but if somebody's been stabbed 4 times, we would like to be able to use that. And it's still we're meeting with Senator Albert for 8th, but I just wanted to throw out there, try to get how to pull this particular out. Jay and Charlotte, I don't know if you have any thoughts about that.
Charlotte,
Can you, it broke up a little bit at the end. Could you just repeat what you just said?
Yeah, just thoughts on, okay, so this is SB 359, and it made it all the way
Right.
Senate House. It had a whole bunch of stuff in there. I mean, there's stuff around gang courts, but there was a particular clause around violence and using, for lack of a better word, the prior bad acts, being able to use that as evidence of the character for the defendant. And we have it, already in law, but it's just related to, I guess, child sexual abuse. And so we're trying to pull that out and put it in terms of domestic violence. And that, there's, a series of other states that already have that.
Well, the only hurdle I see difficulty is, and maybe I'm not looking at this the same way, would be the in the context of the admissibility of other acts, which is prior acts of domestic violence, and a long line of recent cases that are coming out that are very specific about using that kind of evidence for character. So I think distinguishing.
To codify, what was interesting is it made it all the way through the bill. And so I guess the query becomes, do we just keep it in this bill with Albers that has, gang stuff and accountability court issues, a huge range of issues in his Safe and Secure Act, or do we try to pull it out?
So Natalie, I'll actually, I'd like to share as well. Thank you for bringing this one up. I think I might have glossed over it a little bit in the earlier presentation, but you're absolutely right. This one got all the way to the end of the session. It was voted out of committee. It was presumably had support and would have passed, but for whatever reason, before sign died, they did not call this one to the floor for a vote. As I understand it from some conversations, it is highly likely to be introduced again in some revised form. So as Natalie kind of pointed out, there may be some changes, there may be some pullouts, but going to that first and really huge piece about the presumptive admissibility of prior acts of domestic violence or history. That is one of the key provisions that was in there. And I actually had a slide here to show a little bit about what Natalie was describing. What the proposed bill actually said is right here. And so it would provide that, in a criminal or civil proceeding, where there's a family violence offense included, the evidence of the accused commission of family violence or domestic abuse shall be admissible and may be considered for its bearing on any matter to which it's relevant, which I believe may address kind of Charlotte's concern as far as admissibility and whether or not it's being admitted for a proper reason. And so the relevance question would still be in the judge's discretion, I believe. But it sort of streamlines that hurdle for prosecutors in terms of trying to go back and forth with hearings and motions to question the admissibility of some of that evidence. One of the things we frequently hear from victims is that certainly when they get into civil proceedings, I hear it a lot, that judges are not considering the prior history. And certainly in criminal cases, I've heard where a lot of the prior history was ruled inadmissible. Now, again, that's a case-by-case basis to some degree on what reasons the judge had for not admitting that evidence. But I think the goal for Senator Albers and the prosecutors that worked with him on this bill was to kind of streamline some of those evidentiary questions and move these cases. There were a couple of other things.
I don't know. I'm not trying to. I don't understand the does it contradict? I think it's a great idea, and we definitely need it because victims receive 100% assault of character while, defendants sit up there in court trying to look like Mr. Rogers. And any tool that we can have to level that playing field for victims, I absolutely support. I don't understand how it doesn't contradict with 24-4-404, in which character evidence is not admissible to prove conduct.
Yeah, so
maybe I'm not understanding.
Well, I'll, without getting too much in the weeds, so as lawyers start kind of bantering
Right.
around a little bit, I do think that there was close collaboration with Senator Albers and I want to say the Fulton DA's office on this aspect, and GCFV was also asked to kind of provide some information and data. I think that again, the goal here, there is the current evidence code, which exists. And so for folks that are not lawyers, 404B evidence is basically prior bad acts or any bad conduct that occurred in that, that might be relevant to the case. There is a method for introducing character evidence, but what's typically required is a 404B hearing prior to the case or the case going to trial. That would make a decision where the judge would decide one by one what evidence is admissible. And so certainly this provision would bump up against that. And so I think that is certainly a conversation that will be had as we proceed with whether or not this bill is reintroduced in the prior form or in some revised form. So again, without getting too deep in the weeds about what it will or won't do, I think that's the goal. But you're certainly right that the question is, what is the issue or the relationship with 404B evidence?
Right. I just think we need to be prepared to answer that question.
You're
Well,
right.
the good is this is Natalie from the Fulton County DA's office, is that the person who wrote this was Mike Carlson. And so like he's the,
Guru. Yeah.
Yeah.
Yeah. I just think we need to be prepared to answer that question either here or have our prosecutors prepared to answer that question in court, because even if the law passes, a court could still say, and I know I'm getting a little bit too into this, but it might be relevant, but if the prejudicial impact outweighs the probative value of the evidence, it still might not get anyway, even with that presumption. And so I just, we just got to be ready.
And I wish I could print some of this out.
I just don't see the defense bar.
Yeah, and I think they saw those issues at the committee, I guess, in Judy's last session too. So I think Mike's pretty prepared, and we can kind of brainstorm whatever you want to do.
Absolutely.
I would be happy to do that. I'd be happy to, however I can help support this effort and make it perfect so that we have another tool, because we need all we can get. I would be happy to help with that.
Okay.
I'll point out a couple of other things that were in the bill last year or last session that may or may not again move forward if this bill is reintroduced. They also proposed a 5-year minimum sentence for a second family violence offense conviction if that person, when the police intervene in that incident, if that person is also in possession of a firearm. And I thought that was an interesting provision because, again, we talked about this earlier. Georgia does not have a specific law right now that prohibits family violence offenders from being in possession of a firearm. So in a way, this kind of, to me, is a backdoor into that. And so maybe interesting provision that may also be up for debate as this moves forward. The other thing is that the bill has a definition that sort of expands, what we understand to be family violence offenses, but it has a term called a domestic violence felony, and it appears to expand the qualifying crimes and relationships. So again, there's a lot in this bill, as Natalie mentioned. It even, to be perfectly frank, the domestic violence section is just a very small piece of the overall bill, which is, as she mentioned, aimed towards gang activity and some other issues. So I think it is highly likely that this bill will be reconstructed, and we certainly welcome folks who have an interest in this to collaborate with us, Senator Albers and Mike Carlson of the Fulton DA's office, who is primarily the drafter of this, as I understand it. Mm-hmm. All right, so thank you all for that. Of course, this might bore to death some of the non-lawyers in the move, but it gets me a little bit fired up and excited to banter that kind of way. So I hope that was enjoyable for at least some of us.
We did have one question, but I think it's for this bill. Is it any previous history or only history with the same person, same victim? So I think it's any.
I think it is any, and I think again, and certainly the questions of relevance that we were just kind of talking about and prejudice would be in the judge's discretion. But I think it would be any evidence that the DA or the prosecutor is aware of that can be introduced as to show that a history of domestic violence conduct by the defendant. I think too the prior history does not have to be specifically conduct where law enforcement intervened. So for instance, you may feel like, okay, there was some conduct that occurred. This is, again, my understanding from conversations last year, some conduct that occurred between the parties that was not where police weren't called. But there may be some evidence or proof of that conduct. That would, again, be a question of is this also presumptively admissible under this provision? So I guess lots of questions, lots of fun stuff for lawyers to haggle about. But we shall see. This is something that the commission is certainly watching. Primarily, we are supportive of what its aims are. And so we look forward to working with the people involved to try to move this one forward. All right, so I'll go back to Jamila if there are any others signed up at the time.
Yes, there, Chris from Georgia Parents for Kids Rights. Mm-hmm.
Okay, welcome, Chris.
Let me see if he's still here. I don't see him. I don't see him on the list anymore. And it's one other one, Thomas Kadri from the University of Georgia School of Law.
Okay, excellent. Welcome, Thomas. Please unmute yourself and go ahead.
Thank you so much. Yeah, Thomas Kadri here from UGA. I also work with the Clinic to End Tech Abuse up at Cornell University, which studies kind of the intersection of technology and intimate partner violence. And I just wanted to flag a couple of initiatives that I and some of my colleagues have been working on outside of Georgia, but that might be of interest to folks in Georgia. The first is a bill that would make it kind of easier for survivors to get out of shared family phone plans and perhaps other utility contracts. And as some of you may know, there's been movement at the federal level to pass a bill that would provide this kind of protection to allow survivors to get out of shared phone plans without incurring any fees, and to kind of have a right to do that even if the abuser, who's a primary account holder, wants to try and prevent them. This bill would make it so that the survivor could get out and couldn't be charged for kind of doing so. And I've been doing some work at the state level in New York, trying to basically expand the protections both to cover other types of utility contracts, not just phone contracts. So getting out of maybe a shared, electricity contract or cable TV and things of that nature. And also to make it so that the survivor would be able to exercise that right based solely on their own self-attestation of abuse, rather than having to provide some sort of third-party corroboration that they had experienced some kind of abuse. The federal bill, if it is passed, and it's now passed both the House and the Senate and is just waiting for President Biden's signature, hopefully any day now, that requires a survivor to provide some sort of third-party a corroboration, like a police report or a signed affidavit from a care worker of some sort, saying that they had experienced abuse in order to get the protections of that bill. And so something that my colleagues and I have been thinking about is trying to basically enhance those protections at the state level by expanding it to other domains and to allow this kind of severance from these shared contracts based solely on a survivor's own self-attestation. So that's one issue we've been working on. A second one that I'll just mention really briefly concerns data brokers, which are companies that kind of traffic in, personal information, selling, sharing people's, names, addresses, and this kind of ties into some of the confidentiality programs that we were talking about earlier. But these data brokers, they kind of make people's, names, addresses, phone numbers, and other identifying information accessible online, often for free or for very cheaply. And of course, this poses all sorts of risks to survivors. And so one legislative initiative I've been working on at both the federal and state levels is to essentially force data brokers to permit a kind of unified opt-out or deletion of somebody's personal information all in one go. So at best, what we have now is this very disaggregated process where a survivor would have to go to each and every one of thousands of data brokers and try and opt out, have their information kind of taken down. And some work that we've been trying to do is to maybe push a legislative fix here, which would create a sort of centralized opt-out process where a survivor would just need to fill it out once and then have their information kind of concealed from all of these data broker websites all in one go. So if either of those initiatives are of interest to any folks here on this call, be happy to talk about them more. But thank you so much for giving me the space to be able to share that.
Well, thank you so much. And that is actually for within the commission, certainly a hot button issue. We at our conference just this past fall, just earlier this fall in September, we had a great keynote presentation on this very issue on tech abuse and all of the ways that abusers are able to either access or continue to harm victims through use of technology. And so those are actually great issues you've raised, and we would certainly love to pursue further conversations and developing some policy around that for this state. So really appreciate you coming forward. We look forward to following up and being in touch with you on that.
Thank you.
Thanks so much. All right, Jamila, was there anyone else?
Joanna Helsby from DeKalb DA's office. She put an issue in the form.
Okay.
Hi, how you doing?
Hi, how are you? Thank you so much.
Absolutely. This is something that we've just kind of been seeing, and I've seen both in my time when I was in Fulton as well as in my time in DeKalb, but we often have victims who believe that they have a TPO, and when an offender comes back to a location, they're letting officers know that they have a TPO, and you have the officer looking it up either on the TPO registry or elsewhere, and they're not able to locate it because in fact it's a probation condition or a bond condition. And you often have offenders not being arrested at the scene because they don't believe that they have grounds. My thought would be that if there's a way to incorporate those bond and probation conditions into the TPO registry, that would help the victims, A, their safety at that moment, but B, to have the report sort of not read, the victim said that she had a TPO, but we found that that wasn't the case, or something like that, which you see a fair bit of time as well. And then it's kind of a subset of that. Not all officers understand or have access to the TPO registry. So a way to integrate that TPO registry into GCIC or NCIC, as some of the other states have been able to do, so that when an officer runs an offender on scene with their just general criminal history, it will pop for them that they have a TPO or a bond condition, et cetera, pending. So those are just things I've seen.
Excellent topic and issue. Certainly, I concur with everything you said. We have certainly seen that as well at the commission when we have talked to victims and talked to others about these issues, legal advocates and so on and so forth. So this is certainly a critical issue, and I think there's a number of ways that we can start to brainstorm approaching this, including maybe some administrative fixes, maybe or maybe not involving a legislative change. So we would love to continue that discussion as well with you, Joanna.
Can I jump in on this one? That actually passed a few years ago. Those protective orders, criminal protective orders, orders prohibiting contact, sentencing and bond orders prohibiting contact are supposed to go into the protective order registry, and it was passed in, I want to say 2016, 2017. I think the problem is really with the implementation, that these orders are not, and there's been a lot of kind of back and forth about that the orders are not being uploaded into the protective order registry.
You're absolutely right, Charlotte. And we had a meeting, we had a listening session, I want to say either earlier this year or late last year, with the clerks administration, clerks associations, and so on and so forth. And what they've kind of presented. That's why I mentioned that this could be more of an administrative fix. Right. And I think what they've mentioned is, potentially the drafting and development of some forms that would become approved at the state level, that or amending existing forms that are used to go to GBI for GCIC purposes to enter into the registry.
Yeah, I think it's a big issue. There's actually one of the jurisdictions last year before last, talked about a victim, a woman who was victimized because the criminal protective order wasn't uploaded into the registry and it wasn't enforced. So.
Yeah, I've heard many stories as well. I've had victims to reach out to us and share stories around this issue. So it certainly is prevalent enough that it should be addressed. And I think we certainly could use some collaboration in this area to look at the previously enacted law and figure out what fixes need to take place. But we have to work closely with, as I understand it, the clerks associations.
And Judge Manning and Amanda Blanchard has placed some good information in the chat, but we do have a hand raised. Lindsay Smith.
Hi, yes, ma'am. Thank y'all. This is my first time getting to sit in with any of this. I'm actually a former probation officer and my caseload was primary family violence offenders. And this is one that I used to see frequently. It would be on a probation order of, no contact, no violent contact, whichever variation you would see. But 9 times out of 10, I would get the victim calling me saying, well, law enforcement told me we have to call you. And, as a probation officer, it's one of those, like my first instinct was, okay, let's knock out that warrant. But, that's a day or two later and taking in front of a judge and saying, well, the victim said there was contact, not having the in the moment officers respond proof of it. And I think definitely that's also a law enforcement training issue, that, the victim shouldn't have to carry around the offender's sentencing order that says, no, look, it's right here. And the first response should never be, you call your probation officer, especially if it's a day shift officer, pick up the phone, take the extra steps if you're not sure, but I think it's a training issue there also, not even just not even just like the documentation being entered, but some officers also not understanding.
Mm-hmm. You're absolutely right. Thank you so much, Lindsay. Judge Manning, welcome. Hi there. How are you? Judge Manning, are you still
Sorry.
there?
Yeah, sorry, my green screen's up because I was in court. So in our last judges training, we talked about this, and there was going to be 2 or 3 counties, the smaller counties, that were starting it kind of as a pilot program. And I talked with Tina Robinson, the clerk of Fulton County, and I sent her a copy of the training that was on it. And she said she would get with folks and try to figure it out. But there were 3 smaller counties that were going to do this pilot program to see if it worked. Because we do have a lot of people, when I do TPOs, they're bond conditions. And just because there's bond conditions, I guess they feel they're protected. So they don't go to get a protective order or vice versa. And I try to tell people with protective orders, they're like, well, I want to dismiss it. There's a bond condition. I'm like, well, bond conditions can be modified, that quick. So there are a couple of people that are, if you want a sandwich, you make that are doing the pilot program. So hopefully, they'll get it together soon.
Absolutely. I appreciate that. And I think I vaguely recall, I think we've had, I know maybe the Cherokee County clerk has been actively involved in this. And so, it's great that folks are recognizing it and that it's being discussed. So we all need to, in my mind, I think it would be certainly helpful to get a multidisciplinary collaboration on this topic and maybe meet to figure out what the best approach is, because again, this could be more of an implementation and / administrative change that the state can make to make some consistent procedure around this. So that's an excellent conversation as well. Anyone else? Okay, hearing none, I will move along. Again, this has been an excellent conversation. This is something that as the commission, we look forward to each year, because to us, we don't want to sit in a silo and make decisions and determinations about policy direction for Georgia without hearing from the people on the ground and other people who are impacted or working with these potential policy issues. So it's really important to us to set the stage here by beginning a conversation and then moving forward with collaboration to advance the change. So I am grateful. This is probably one of our largest roundtables yet, and I'm really excited about that. In fact, it kind of alarmed me when I saw the final registration numbers yesterday. I thought it was an error in Zoom, but luckily it was not, and all of you folks made it today. So thank you for coming. I'll give a few announcements and then we'll adjourn. Looks like we might be a little bit early, and these are just some commission announcements that I want to share while I have a captive audience. So please give me the point of privilege on that. Want to just give an announcement to save the date. We are already booked for Jekyll Island next year for the Family Violence Conference. This is also another great opportunity to have some networking discussion around issues in Georgia that are occurring. We have lots of networking opportunities. We have lots of great conversations and keynotes and workshops each year. And so I think if you've never attended, please check out our website, make a note in your calendar and consider coming to the Commission's conference this year, where some of these issues come up and get discussed. The next announcement I'll make is if you're not aware, this year GCFV was successful in getting some funding from the state to launch a new resource for victims. This is for specifically victims of murder-suicide offenses. So typically these are more like surviving family members. And what we've launched is a statewide support group program. It is an online resource that family members who are victims or have lost a loved one to a murder-suicide can register and sign up for. It is facilitated by a trained clinician. And we have also provided specific training, targeted training around the issues that happen with murder-suicide, which is a little bit different from just, when there's a family violence homicide. Certainly not to minimize those, but to just say that there's a little bit of differences. We have a family violence murder-suicide coordinator on staff. Her name is Kylie Elliott. If you don't know Kylie, I think you should. So get to know Kylie. She's doing a great job with this program. The clinicians are really excited. We've already facilitated or at least initiated 3 groups. And so far the response has been excellent. So make this a resource that you take note of and keep on your radar. And where appropriate, please refer folks to us for the murder-suicide support groups. We also have lots of training and workshops coming up over the next year. Please check our website for training and events that GCFE sponsors. Oftentimes these are free of charge, so or for very low fees. So if you're interested in finding out more about what issues we're talking about, please keep our website in mind and look up our training and events. And with that, I don't have any other announcements. Stephanie, are you still on? Do you have any other announcements or comments before we adjourn?
Before Stephanie, I'm sorry, but I'm just going to put in the chat, our RFPs are open for the conference. So
yes. Thank you, Jamila. Excellent. See, this is why I have a team. They have to get me together. So
yes,
if you are, yes, if you are someone who has delivered or facilitated previous trainings on any topics of interest to you, and you want to be considered for presenting a workshop to our conference attendees, please visit our website and submit a proposal for a workshop. That will be open through the end of February, and then we will review, and we have a committee that reviews those proposals and make selections. We often have around 30 or 35 workshops each year, and it's usually an excellent experience for those who attend. So if you have ideas for a workshop, we would love to hear from you. Thank you so much for that reminder, Jamila. And as I mentioned earlier, we also have commission meetings on a quarterly basis. Those are also on our website. The next one is next week, where we will again be talking a little bit about legislative priorities. So if you'd like to attend that as well, please sign up and get the link to join us.
And I think Karima has an announcement. I'm sorry.
Karima, sure. If you have an announcement, go right ahead. Karima, are you there?
Sorry, the mute. So the Georgia Coalition just got a grant from the Department of Justice along with the Fulton County Conviction Integrity Unit to look at wrongful convictions for those women in Fulton County and other counties around the state who've been wrongly convicted. And we are looking for a project attorney. I posted the job announcement in the chat. So if you know of anybody or you yourself might be interested, please send them our way. We will be conducting interviews very, very soon. Thanks.
Thank you so much. That's exciting, Karima. Excellent work the coalition is doing. And I think someone asked a question in the chat that I did not announce out loud. But yes, regarding the conference, the dates are September 17th through the 20th. And we look forward to seeing you if you're able to make it. Save the date announcements will be going out soon. If you're not signed up on GCFV's listserv to get automatically receive emails and announcements from us, I promise you we do not inundate folks with emails, but when important announcements come up, we want you to certainly have your finger on the pulse and know about what we're offering. And again, I think that concludes my announcement. But again, thanks to everyone who signed up and showed interest and came and shared today. We certainly appreciate it. It helps us with the work that we're trying to accomplish. And Stephanie, if there's nothing further, do you have any final remarks before we adjourn?
This has been wonderful dialogue. Thank you all for your time. And if next year's conference is better than this year's conference, I'm just not going to be able to stand it. So I look forward to keep working with each of you.
Excellent. All right, that concludes our roundtable. Thank you all for being in attendance. Thank you for your time. And I'll give you 15 or 14 minutes back for your day. Thanks all.